First of all, I want to apologize for this technical problem, this connectivity problem at home. So I'm going to speak about trade and environment and the Brazilian case. I was commissioned with this task. Next slide. The structure of my presentation is first to touch upon Brazilian exports. I'm going to give you tons of information for you to see some elements that are important for today's discussion. Continuity and change in the agenda structure. After that, we'll discuss the connection vectors between these two agendas, trade and the environment and climate. The third part is Brazil facing this linkage between the two agendas, the government's and the business's view that have to deal with this linkage. The fourth point is the exports of Amazonia bioeconomy products. This is important in Brazil. Bioeconomy is considered an important asset. Countries such as Brazil and Amazonian countries, everything related to their exports will see what their issues are to develop bioeconomic exports. And then I'm going to make some conclusions and recommendations. Next slide. The first part, this one, it's okay. In this first part, how the Brazilian exports are made up, the product composition or breakdown. This is a long period ranging from 1960 to 2000, and after that to 2020. International trade in Brazil, we are used to it, especially listening and discussing and having conversations. We see two periods, 60 years since 1960 to 2020, the first period until the 2000, and this first period, what we can see a very important change in how the agenda is made up, and I mean the export agenda, from the manufacture project from 2.2% to 60.7%. The commodities, on the other hand, range from 91% to 23%. So there has been industrialization here. And in the period between 2000 and 2020, there's an opposing movement. And curiously, the figures are opposite, because manufactured products in 2000 amounted to 60%, and now they are 28%, and commodities that in 2000 was 23%, now they increase to 57%. So the relationship is vice versa, so to speak. These movements are continuous. There's a sharp movement that stops, increase sharply or markedly. And then in the 70s, we saw that manufactured product as transport material, equipment, chemicals, most of these products do not share the same sequence. Next slide, please. I want to draw your attention to a topic. Aside from that period that I mentioned with a huge or marked increase in manufacturing products, aside from that variation, we see some continuity over that same period from the 60s and to the 70s. The comparative advantages, the metrics of sector specializations for exports are focused in intensive industrial sectors, speaking from the natural resources point of view, agricultural commodities, mineral commodities, and energy commodities as well. In this area, the concentration in the same industrialization period, including this period, this current period, within the industrial sectors based in natural resources, the highest growth are the ones that were attached to the first industrial period, paper pulp, steel, chemicals. This is the first transformation for natural resources. This is what we see in the first industrialization stage, and they are resilient to the decreasing share of industrialized countries. Next slide.
Então, esses são os setores, como eu dizia, que mais resistem à queda de participação de manufaturados na pauta. São os setores intensivos em recursos naturais. São os setores da primeira transformação dos recursos naturais. Né? Em contrapartida, os que realmente perdem muita posição na pauta total do Brasil e de manufaturados são os bens.
Let us consider also the technology-intensive goods, for example. Also, labor-intensive goods, and there is a fall as well. And in 2000, from 2000 onwards, in the second stage of manufactured products, there's an increase in the share of commodities, agricultural products, mineral products, which are the foundation of our natural resources. So Brazil, since 2000 onwards, in the industrial sector, there is a reinforcement of specialization in natural resources. So this is what has to be summarized to indicate what happened in this first moment. So we may wonder, what is the relevance of all this to the subject and to Brazil? So there have been a lot, or there are many natural intensive goods, and this has to do with trade measures, and we have to take into account environmental measures when we think about the emission of pollutants, etc., which are characteristics of the DNA of our natural resources. When we speak about the environmental agenda, the priority on that agenda, the priorities, we have to bear in mind the intensity of the emissions, and that is related to the environmental analysis. That's why Brazil, as a big producer, first of industrial goods and then agricultural and mineral products, Brazil has a great potential for products related to environmental issues, considering pollution and emission of gases. when we speak about the 90s, there were some studies made by FUNSEX in Rio de Janeiro and UNCTAD identificaron identify potential vulnerabilities in Brazilian exports. And the big businesses also realized that there were voluntary certification schemes, and that is a risk, potential risks. So the companies were able to adjust. They were big businesses, and they were, for example, cellulose producers, and they had to face the demands of voluntary certification, but that was a condition de facto to enter certain markets, the European markets. After the first studies in the 90s, the size of the companies, also the size of exports, especially billing, exports to the European Union, were the variables, the key variables to explain the capacity of adaptation of these businesses. And of course, the exports to Europe represented a big market, especially for big businesses. And as I said, they adjusted themselves to the new requirements. Now, these characteristics were not present. Businesses had to face bigger challenges. Okay, now the next one, please. Next slide, please. There is an evolution in the 90s, and then in the year 2000 onwards, we had to perceive the risks. From the one hand, there were natural resource intensive industrial sectors which added their activities to the agricultural and competitive sectors, and the intention of emissions at that moment. Climate change was a protagonist on the environmental agenda, and the most significant criteria to evaluate businesses from the environmental point of view is emission intensity and how those emissions are reduced. The migration of the environmental agenda lays focus on environmental agenda. We speak about pig iron and steel, cellulose, especially in those sectors who were not polluting sectors, but also in sectors which were not polluters, but which generated carbon emission and other gases. In terms of sectors which are potentially the target of environmental and climatic measures, the situation changed when the agricultural sector got in and with the migration of the environmental agenda.
Now the second part. Next slide, please. An effort to identify the channels or vectors that comes close to the trade agenda, and it started to get distorted. This intersection we see between these two agendas, the trade one and the environmental one. And there are 5 different vectors, and there's a differentiated impact as well within this intersection. The climate and environmental negotiations, the WTO negotiations, also the preferential trade agreements and the sustainability and voluntary regulations and unilateral trade policies of developed countries. Through these 5 points, the climate agenda comes close to trade, and there's some sort of interference with the trade agenda in this side, in this aspect. This factor that you can see is not going to create a big impact, but it creates some sort of shaping a regulatory and institutional structure because they are multilateral agreement, and this will influence the perception of how important this agenda is to trade. We have Stockholm meetings and Rio with a period of 20 years between both of them, and there are some multilateral agreements that are restrictive to the trade of certain products. In 1973, after the Stockholm Conference, this is a convention on endangered species. It's not shown on the slide, but it's important to mention that there's the Kyoto Protocol as well that plays a key role here. It's a framework structure, the first effort to face the big challenge in this environmental agenda, and this is the climate challenge. From there on, this is some sort of migration. I'm not saying that the other agendas are pulled aside. We know that regularly there are conventions and meetings that touch upon the environmental and trade agreements, but from Kyoto onwards, what is key on the agenda and receiving media attention is the climate agenda that is different from the environmental one in terms of pollution. In the traditional agenda, we were always only dealing with pollution. It had some sort of domestic and global dimension. There are some instruments dealing with transportation, cross-border transaction for hazardous wastes or products, and there are many conventions and WTO provisions in this regard. There are also conventions on hazardous products, as I said. Pollution is dealt with at a domestic level because it is constrained within a region or a country, but in comparison, the climate agenda is global by definition. It's not good for a country to face the climate challenge and other countries do not. If you ignore this climate agenda, this can lead to a negative outcome, because if a company does some mitigation measures and the other one is not interested about emissions, then the climate atmosphere becomes worse. We will be aggravating the situation. When we speak about a global agenda, we need to rely on what other countries do. So there's an interdependence among countries, and this interdependence relies on national or domestic climate measures and agendas that are going to look after the international agenda. When the environmental agenda migrates towards the global dimension. So all countries to a different extent, we can see that at the end of the day, all countries will be supervised in terms of meeting goals and targets. If we see that this agenda affects the trade agenda, we'll see some frictions that I'm going to touch upon later on. Trade and environment in the GATT and WTO agenda. This area did not make huge progress. We can see some paragraph of Article 20. There are exceptions to multilateral trade rules, the adoption of measures dealing with human, animal, and plant health. These are within the general exceptions of the GATT. These measures are taken to preserve or conserve the natural resources. They should not discriminate against local or domestic production. We also see some elements referring to the disputes within the WTO regarding the interpretation of these paragraphs. There are some countries that opposed to these measures on a discriminatory basis and protectionist basis under the guise of being well-meant. In 1971, it was created a group within the GATT about environmental measures. Basically, at the beginning of the 90s, next slide, the Uruguay round. No, next one, please. It's not this one. Next one. No, I'm sorry, it's not this one. The one before this one. 2 slides back, please.
Não, pode descer, é o seguinte, é o depois. É o que vem depois desse. É o que sigue, é o que sigue. Isso.
This is the one. At the Doha round,
há também lá projetos de que se continue discutindo certos temas, mas não como objeto de negociação.
The project that continue dealing with some topics. And there were also negotiations, trade obligations, and WTO rules. Some agreements have trade obligations, as well as the reduction of trade barriers on goods and environmental goods. We see 2 negotiation cycles within Doha. Countries submit their schedules, environmental schedules, but no conclusion is reached. Countries were against this, including Brazil, and there was some sort of agreement between developed countries. We continued discussions or discussing certain topics, but we did not reach to any agreement at all about a multilateral agenda. Next slide, please. And here we come to the main vector, and it's the linkage between 2 agendas. The 2 agendas, I mean. The preferential agreements of trade North-South, the European Union agreement, United States and Canada, with developing countries. That was in 1993 or 94 at the beginning with the first initial agreements with the EU. This was dealt with as a cooperation issue. Over time, and due to the developed countries' pressure, this topic gains momentum in the agreement. It started to create some linkages, and until recently, we had access to mechanisms in this agreement, but they are kind of controversial. For example, the new agreement with the NAFTA or other countries regarding environmental topics, labor topics. The environmental agenda is tackled here. The right to work in NAFTA 2.0, the idea to access dispute settlement mechanisms are created. So we have this access provided. We still do not have a mechanism in place. The agreement between the EU and New Zealand, I think they already do have this mechanism. There are discussions about the trade chapter, and they can be brought to the dispute settlement mechanism. In our agreement with the Mercosur, we do not have this. In our agreement, neither is the case with our agreement with the EU. There's an interpretation tool or instrument that's called side letter that allows for discussing some sort of having a mechanism in place once the agreement is in force. Next slide, please.
With the preferential agreements, we have to see which are the main environmental clauses. One has to do with the compliance of policies and national legislation, together with the multilateral environmental agreements signed by the different parties. That's a commitment, that is to say, to make all these agreements binding. That was the first thing, which was the objective with this agreement. The second thing is that these environmental policies may impact trade flows. What does this mean? That means that these policies have to be more lenient in order to foster investment, or to restrict flows due to policies or protectionist policies. There were also, we may mention more recent European agreements, which are related to, for example, illegal fishing and subsidies to fishing. That is the example of the TPP. That is what developed countries do vis-à-vis developing countries. This vector was rejected by the big developing countries, India, Brazil, South Africa, Indonesia. These countries in general do not have preferential agreements with developed countries, and there are no trade agreements dealing with sustainable development. Next, please. So far, the main vector, this vector introduced binding clauses related to the environment, and they were mandatory. On the contrary, there is another vector, and there is another concept, which is the voluntary standards of sustainability. They are practically 30 years old now because they originated in the 90s. There were Brazilian companies which were involved with green sticks and eco labels, and those which proliferated in Europe. They had potential impact on conditions of access to markets to developing countries. We're speaking about processes of production also. So these are voluntary instruments, and depending on the importance of those products, the vision consumers have, they may enter the market, but they are voluntary. I stress this. They are not mandatory. But this is a new concept. There is an evaluation of the different attributes of the process of production, not only the final product. And this is going to gain weight with the migration of the environmental agenda towards climatic agenda. Because we're speaking about the evolution of a product, just a stage in the production chain. There was low emission as a result, but we have to remember that in the previous stages, emissions were enormous. And this is going to change with the evolution of the climatic or the climate agenda. Next, please. In the 90s, cellulose, apparel, shoes, all these sectors had to face these new instruments. And consumption enterprises had more difficulties to comply with the requirements related to certification methods, especially it was very difficult to trace or to map what happened in the first stages of production. Suppliers were responsible for those first stages. So what it was responsibility of suppliers from the environmental point of view. Let me mention the Forest Stewardship Council, which created in 1993 a coalition of NGOs and companies to set certification standards. And there are also the case of smaller companies we have to say that, for example, in the Brazilian cellulose sectors, it was verticalized with its own production of forests, and hence it was easier for these to comply with their requirements. A company with these characteristics, Europe was a very important market, but even today, for some companies, it is very difficult to comply with all the requirements. Next, please. There are some problems emerging from voluntary standards. The first remark these requirements until Doha. The debate was at the CTE. It was not susceptible to negotiation, but to debate. The clauses, for example, say that the parties have to collaborate during the process, everything based upon wishful thinking. As I said, they were not mandatory clauses, but there was a proliferation of private instruments which evaluated the products and the processes. And with the advent of the climate agenda, there was a concern with the products which were already on the market. So it was not a question of the product itself, but also the process of production of manufacturing before the final product. As these initiatives are private, they were not subject to the WTO rules, but there appeared a regulatory gap at international level, and this renewed the concerns of developing countries in terms of protectionist risks, which were associated to this kind of initiative. The criteria which are imposed by these procedures. So the initiative is significant, and who is willing to implement a standard? Why were these voluntary standards created? First, supply. The supply of standards. Standards are helpful in managing value chains, the reputation of the trademarks, the exploration of the market niches, consumer sectors, in order to relate this to demand. For example, there was a concern by consumers in terms of health and environment. So the standards tried to reflect this new agenda. There was a chain which eventually reaches the consumer. There is a recent study which shows the evolution of sustainability standards, and the conclusion for 14 commodities, there are some standards which cover, for example, coffee, significant sectors which are marketed in the world. There is a strong tendency, stronger in some sectors than others. What is marketed in the market responds to some standard. And Brazilian exports of agricultural products have to face this kind of initiative, and this has happened for years now. I'm speaking about sectors such as sugar, ethanol, cotton, and soy. And they have their own certification instruments. Let me give you two cases in Brazil of certification. One is the soy moratorium and the RSS, and in the case of sugar, Bom Sucro. They comply with the requirements. There are multinational enterprises in Brazil which comply with these standards. There are many types of standards. Let us have a look at the typology. That is to say, we have to bear in mind the origin of a standard, whether there is private, civil, or a collaborative arrangement. We have some standards which are applied exclusively in one company, and there are others a group of companies which produce the standard. We have standards which are elaborated, for example, by representative of certain companies, and the result is the advent of standards. As you can imagine, that these are decentralized, non-regulated activities, and there is a multiplicity of systems with different requirements, criteria, and processes, which not necessarily converge. So we may say that there are costs of complying with this variety of standards, but on the other hand, if you have many standards for just one product, you eventually affect the credibility of those standards. So you may wonder which is the pattern you have to apply. Which are the sustainability requirements, labor requirements, human rights? So which is the best standard? So the multiplicity of standards has this effect of or to weaken the product and the quality, the environmental quality and social quality of the product. How can we face or solve these problems? It's complicated. Let me share some ideas. There is an alliance, which is the International Social and Environmental Accreditation and Labeling Alliance, which define meta standards. Another option, or perhaps we can resort to those two things, the regulatory sphere of the states may get into this stage. As I said, this has not appeared preferably in trade agreements, but it does agree in the recent agreement with New Zealand, and that subject is treated generally.
And avoid protectionism. Next one. Now we come to the last vector, the latest one. This is the closest to both agenda, unilateral discussions, and the EU is working hard on this, and it will affect all other countries. So in the EU, we see two examples. One is the CBAM, the Carbon Border Adjustment Mechanism. The CBAM, that's the acronym. And the deforestation-free regulation based on the European Green Deal. This is the agreement signed to reduce emissions by 2030, and then rates or indexes are doubled but it's quite ambitious. What is really polluting the policies of the EU? I'm not being literal when I say polluting, but this policy is expanding towards others that are specific about environmental and climate topics. The CBAM, I want to touch upon the CBAM, this Carbon Border Adjustment Mechanism. This mechanism is within the European structure to compensate European producers in relation to emissions, so they should take care of the carbon pricing. When that effort does not translate into trade partnership disruptions. This system, the sectors, the high emitters, these countries need to buy licenses or emission licenses to emit a certain amount of carbon, and if they emit less, they can sell those credits to other companies with carbon targets. The carbon pricing is regulated. So this has worked, and the high emitting sectors are within the CBAM do not pay the licenses in full. They buy half of the licenses and they receive the other half for free, but from that point on, the emission trajectory has come down or been reduced. That's the goal. So this entails a different sort of costs, carbon costs. If they paid the full carbon price, imports would also have to pay the full carbon price in force for the EU. Otherwise, the EU producers would lose competitiveness facing these imports. This is the logic behind it. Sometimes logics is one thing, but the details are different one. But the mechanism so far is this one. The sectors that must pay CBAM are iron agglomerates, steel, fertilizer, cement, electricity, and hydrogen. This is a group of products recognized all over the world. They are emission-intensive products or sectors. The CBAM completes the introduction cycle and the ETS system, establishing an instrument to tackle imports or address imports. This was approved in the EU. It should be in force in October the 1st, 2023 until 2026. Producers there should not buy licenses. It's a trial period to see how the mechanism works. Because there's some red tape involved and the results might differ. The Brazilian importers, the European importers of Brazilian products should buy those licenses. So in 2026, they should not need to buy these imports licenses. And the point is to see how the mechanism works and if it works or if it doesn't work. This is the trial. Then imports after 2026 need to buy those emission licenses. Domestic producers are going to be allocated some free allowances. This might be an implicit subsidy, because if from 2026 the imported products will be paying carbon price in full, maybe the Europeans, before that period, they will be paying only just a part or a portion of the full carbon price. There's some disputes over here and about the consistency in regulations. There are many countries that voiced their concerns before the WTO, and we see the potential impacts on Brazilian exports. This relates to Chapter 72 of SH. This might seem a small number because the exports to the EU are few, because it's not a meaningful market for us in terms of these products. But for Chapter 72, there is an impact, and it does not depend only on how big exports are for the European market. It also relates to the impacts of CBAM on Brazilian competitors. And I mean the products coming from the European Union. So this must be analyzed from Brazil and from the European perspective. The CBAM might be better positioned regarding the competitors and not on a European country level, but the competitors that are beyond the European Union. So this is not clear. So it depends on the impact this linkage is going to have on Brazilian competitors, basically in iron, steel. We should remember that countries are going through an adoption or adherence process. In the case of Canada, there are increasing risks. We need to deal with many instruments at a country level and mandatory instruments. They are not voluntary anymore. So I don't know if the UK and Canada are going to continue following the European model or criteria, or if they are going to be less stringent than the EU. But this is a true risk, and there's a proliferation of mandatory mechanisms. Now, the deforestation-free regulation. This regulates the imports of certain commodities that are potentially linked to deforestation and forest degradation. Many products covered by this regulation are soy, cocoa, coffee, beef, timber, pulp and paper, palm oil, also leather, bovine hide, chocolates, and timber furniture. The paper pulp, including timber, are linked to tropical products in developing countries whose production is identified as having potentialities to incentivize or encourage deforestation. The regulation proposal conditions the access and circulation of imported products to the compliance with three requirements: products must not be related to deforestation. There's a rule called deforestation free, as I said. They are benchmark instruments, quite sophisticated indeed. They can't be associated with deforestation. The next one is that the production of imported goods must respect the legislation in the origin country. And third one, products should have gone through a due diligence process by operators, in fact, the importers, within the terms defined by the due diligence report. So complying with these regulations or laws comes up within the trade agreement, the EU and Mercosur, EU, Chile, and the United States. This is required by this agreement. Are they enough? There are others that need to be complied with. The product cannot be associated with deforestation. This is the different topic here. Is it legal to deforest 10% of a land? No. So this cannot be presented to the EU. This is a unilateral rule by the EU going beyond what is established in trade agreements in relation to binding disciplines. We can see that this rule needs to be complied with. But also, we need to comply with the deforestation-free rule. So, before the product is placed in the European market, the importer should collect information about the product's origin. It's some sort of due diligence process, some research done by the importer about the origin of the product. They should assess the risk of that product being related to deforestation, and in such a case, they need to mitigate that risk. Risk assessment, if it is high, they should consider some topics related to the production countries. The EU established a benchmarking system classifying countries or regions, for example, to determine the producing sector or countries, and according to its deforestation risk, the EU is going to set a ranking of countries or regions broken down by its deforestation risk. So countries are classified in this way, based on the risk, not only the factors related to deforestation, but also corruption, non-implementation of environmental laws, and other factors are considered here as well, not just deforestation. Some of the criteria to be considered in classifying a country's risk need to be based in that benchmarking practice, including deforestation-free taxes and forest degradation and expansion of agricultural land. Also including commitments to reduce deforestation and land degradation within the NDC of a country within the Paris Agreement, and adopting effective implementation measures to penalize activities leading to deforestation and forest degradation. Countries, again, are going to be classified or ranked as higher or lower risk countries or sectors, and the importer, upon considering importing a specific product, will need to see that ranking and to see where that country or sector is positioned, and they might need to do some research to determine whether, in spite of those criteria and despite the due diligence and its degree of risk, they will still choose that country from the list. The importer can do this research, actually. If there's a high-risk country, they can conduct an even deeper assessment. Now here, I'm going to talk about the two regulations regarding deforestations that are applicable with the wording that they have. So this wording of regulations can create some room for hesitation or doubts. The implementation rules are going to be linked to infra-legal provisions in July or August. After public consultation, the implementing regulation mechanism was implemented. This mechanism is geared to implementing specific regulations within the broader framework regulation. This implementing regulation is already in force.
Now we are going to speak about the last part of the presentation, devoted to different vectors and the approximation between the two agendas. Now we're going to say how this occurred in Brazil. Next. So let us see how Brazil reacted with all these evolutions. There were certain the exports of the country were potentially vulnerable, and there was a growing vulnerability with the evolution of the global agenda. Brazil kept both agendas far from each other. Now, we can speak about green protectionism, especially related to agricultural or green Brazilian products. Brazil didn't have difficulties to keep that position. At the WTO, you know that this last agenda did not progress. On the other hand, the preferential agreements permitted the fact that Brazil, both Brazilian agendas were distant from each other. So Brazil did not have a preferential trade agreement with developed countries, which is the main vector of connection between the two agendas. There was an agreement South-South, and Brazil did not include the topic. Next, please. Okay, let us speak about the agreement Mercosur European Union, which meant a new stage in the agenda of trade for Brazil. For example, this agreement introduced a chapter connecting both agendas, and there were some question, and Brazil questioned or objected, and there was a side letter to the bi-regional agreement which showed Brazilian rejection. There were new European unilateral instruments, and this takes us back to green protectionism. What about exporting companies with different intensity according to the sector involved? These topics are on the agenda of several companies in Brazil. From 2000, the first initiatives of labeling and forest certification, and since 2000, there were several sectors involved. But I want to stress that so far it is voluntary, so there are sustainability standards which are voluntary, and according to the market, certain products may be accepted without certification. In terms of CBAN and European deforestation regulations, now it's no longer voluntary but mandatory. And there are many carbon-intensive industries, as you know. This aspect of this passage from voluntary to mandatory has to be stressed if you want to enter the European market or export your products to the European market. So there are implications depending on the size of the company. If you have the capacity to trace the production chain upstream, for example, if the market may define rules to enter the market, and in all these cases, it is worth facing these challenges, trying to adjust oneself to the new climate, the new scenario. Perhaps the companies may opt for exporting to some markets and not others. But regardless of this, there are a number of companies which will have to face the foreign requirements. And this is especially applicable to developing countries trying to export to developed countries. Now I'm going to speak about Amazonia and international trade. I thought it is worth speaking about this. When we speak about biodiversity products, and that takes us to the Amazon region and the forest products which are compatible with the rainforest. The legal Amazonia produces commodities, agricultural and mineral. There is an expectation of diversification And those exports, which are extractive agricultural goods, may contribute. And in 2020, there was a study related to the project Amazonia 2030. Practically $200 billion in the international market for agroforest products, which are compatible. And the Amazonia represented just 0.17%. The main competitor of Brazil are countries which are not so developed as Brazil. I'm speaking about Peru, Bolivia, Vietnam, and Côte d'Ivoire. In this, try to explore the causes of this performance. So we explore the international market and also the Brazilian supply of forest-compatible goods. So the first thing we have to say is there is a great diversity of sizes of markets. Big markets, $1 billion, $2 billion, and smaller countries. On the one hand, European and United States. And in terms of competition and access to markets, there are countries which are not so big as Brazil, and there is a preference system. The technical or sanitary measures may be barriers which are more difficult to overcome than tariffs. And so this takes me to the notion of compliance, considering the size and resources of the markets. And there are goods which are used as food, as health goods. These are the main characteristics of this market. And now let us speak about the exports of bioeconomy, a big supply. It's not only agricultural. We have to speak about the scale of the business. And the main products are more than $1 million, with 30 products considered. And what about the income, annual income derived from exports? There is strong instability, and this makes very difficult to sustain continuing growth. Next, these products, when we speak about SMBs, for example, micro companies, they have difficulties such as access to information, access to foreign markets. But let us imagine that occurs in the space of Amazonia, which lacks infrastructure and which has lots of hurdles to channel its products. It's even difficulty from Manaus to the Amazonia. Next. So the economy of the rainforest has to be fostered and to be a priority, federal priority, in order to foster the development of those communities in the Amazonia. And there are many things to be done. So Amazonia is an example of a state which is absent in the production of public goods. And let us speak about the conclusions now.
Então é isso, a gente sabe que, eu já falei isso aqui, não vou repetir, esses instrumentos vão ter de ser usados cada vez mais, né? O Brasil é vulnerável a isso.
The instruments to be used to see if Brazil is vulnerable or not. I'm not talking about protectionist measures. Next slide, please. The green transition became a top priority together with Canada, Europe, the United States, China. There's competition here. This is going to happen because this is a political and economic point of competition. It's and part of it is connected with the green agenda. We have here some players and actors and partners that can leverage these opportunities. What is a problem to Brazil right now with this concentration of natural resources and energy might be an important asset, economically speaking, as long as we can integrate it with policies and include environmental and climate topics. We have a potential to develop and avoid deforestation measures. So we should not wait for this to come to us, but we need to be more proactive and tackle these challenges and find some other opportunities. So this is as far as my presentation went, and thank you for taking so long. Pedro, thank you so much for your presentation. Now, we'll move on to the comments from Humberto Celi Jr. Did I pronounce it correctly? I'm going to make a brief introduction of Professor Humberto Celi Jr. He's a professor of international law at the University of Sao Paulo at Ribeirão Preto, the School of Law, I mean. He holds a master's and doctorate degree in international law. He was coordinating of the program of postgraduate for Latin America integration program of the University of Sao Paulo. He was an observer of the negotiation of trading services in WTO as a guest of Brazilian mission to the WTO in Geneva. He has experience in the area of law with emphasis in international law, and now he's a member of the international expert group of the Forum of Trade, Environment, and the Sustainable Development Goal. He's a lawyer and a consultant. Humberto, you have the floor. Thank you, Veronica. I want to thank the invitation to this session. Before beginning these conversations, I think when Pedro greeted me, he couldn't hear my answer because my mic was off. I just wanted to say hello to him and congratulate him on his brilliant presentation. He covered many topics. a lot of topics that he developed. So this leaves me with little room to include some other topics, just to add some comments on his brilliant presentation. I want to go back to some of the points he made during his presentation. I want to shed some light, a different light, on Pedro's topic. So, I want to focus my remarks on the European Union and also the deforestation-free regulation, and to assess the consistency of those policies with the WTO rules, without the purpose of making any suggestions to the Brazilian government. By the way, I say hello to all of them who are here in the meeting, but based on some, I just want to reflect on the policy consistency with the WTO rules. Maybe you can arrive to your own conclusions. It's important for the Brazilian government. What's important to the Brazilian government, I mean? Pedro talked about the bioeconomy. I want to speak about the green hydrogen and carbon credits. To know where we're standing, because Pedro expanded so broadly on this topic, the Green Deal, I mean, of this rule, that is the CBAM, is the Carbon Border Adjustment Mechanism, and the EU regulations prohibits the trading, import, and export of specific products that are deforestation related or that come from forest degradation within the bloc countries. So these policies aim at the zero emissions by 2050, to reach net zero emissions by 2050. So when we look at the deforestation-free regulations, just the introduction of it, you are left with the feeling that there are truthful intentions, well-meant intentions, and you can hardly disagree with them. It speaks about reducing emissions of greenhouse gases or GHGs in an objective way by 2050. Also to ban forest degradation or deforestation. So Brazilian peoples, whether we are in this administration or not, researchers and the academia, we all agree on this and with these proposals. So undoubtedly, it's a well-meant goal, but it's also a little bit tricky. Pedro mentioned some of them. I wanted to focus on the fact that despite the well-meant goals, these policies or regulations might affect Brazilian imports to the EU, or at least make them more expensive. And this depends, as Pedro said, on some sectors. Not all the sectors are affected by it or might be affected by it. When we speak about CBAM, steel and iron mainly. So CBAM sets rules to export products in order to level products manufactured in the EU with those of countries that have environmental policies in place, or countries that are implementing energy transition policies. So Brazil can work with countries that have environmental policies aimed at emission reductions. Some intensive industries are subject to the CBAM. I mean energy-intensive sectors such as steel, aluminium, hydrogen, and others. Some other sectors will be included in that list as well. From 2026, products will be included, imported products will be included. So they will require certificate in a platform established by EU countries. So from 2026, for imported products to come into the EU, they should acquire certificates on a platform established by the EU. The price for those certificates, and I want to emphasize this point because this is a very complex calculations. The average closing price of emissions, the weekly average of auctioning permits, emissions for the emissions trading system expressed in euros per tons of CO2. Importers will also have to annually declare the amount of goods imported and the emissions, the embedded emissions, aside from delivering the correspondent certificate. This is complex and a great big question is how this system works and the rules to calculate carbon in products with indirect emissions related to emissions produced by electricity or through producing a specific good. These rules, how do they work? They will be defined by the EU. I want to point out that I think it's possible or even probable that one or more countries understand that their products will receive a less favorable treatment than similar EU products or from any other WTO member state. The deforestation-free regulations determines that from 2025, the products coming from deforestation-free lands can come freely into the European countries. These products will be banned from trading in the bloc, including products manufactured with these commodities. Presumably, these products coming from deforested areas will not be allowed to come into the EU, such as palm oil, timber, coffee, cocoa, beef, soy, as well as products manufactured with these commodities, such as cosmetics and chocolates. And the product schedule should be revised and updated considering the new data and changes in deforestation standards set by the EU. We also establish a benchmarking system, or it is established for each country, that should treat countries differently according to the criteria established at a unilateral level by the EU. The European Commission will determine the level of risk of each country, high, medium, or low, based on the degradation, forest degradation, or deforestation, the use of lands for the main commodities, and all this based on the available data, NGOs, alerts, and other sources. There are two key words here: international trades, stability and being and previsibility. As we know, the access conditions within the WTO are protected by many provisions. In principle, non-discrimination. So these countries cannot apply different measures to similar products from different origins or discriminate against among similar domestic and imported products. Another topic that will challenge the WTO rules is that they speak about non-discrimination. I want to focus on this term. Non-discrimination is a fundamental principle within the WTO that cross-cuts many of its agreements, the preamble of GATT, the foundational agreement of or charter of the WTO. So one of the main goals and ways to meet the WTO goals was non-discrimination. And we should point out here that it was included in the Rio Declaration and in the convention, Framework Convention on Climate Change. In relation to trade-related climate measures, the obligations in non-discrimination are contained in GATT 94, in GATS, that is the General Agreement of Trade in Services, and in the Agreement for Technical Barriers to Trade, or TBT. The WTO members are allowed to discriminate when they pursue legitimate political goals, as long as the measures, the environmental measures related to trade or climate change measures, that is our topic of discussion, are necessary or are related to a legitimate goal, and they should be applied in a way that it does not unjustifiably discriminate against others. These might include environmental protections, also mitigation of the climate change effects, non-discrimination. Where do we see it? In one of the articles present in many agreements making up the most famous nation, the Article 1 in GATT 94, and national treatment, and that's Article number 3. Especially in Article 3, national treatment is the application or levying taxes or duties. Article 3.4 are regulations, restrictions, and demands or requirements, and the most favored nation, or MFN, and NT are related to the TBT, the technical barriers to trade. But Article 3.1, any tariff, rate, or charges on an imported product and that it has not been collected from a similar national product is a breach. So this article tries to verify, because this is a less favorable treatment for an import product. The Article 2.1 in the TPT has the same wording, treatment no less favorable. By the appellate body, required that the panels analyzed the harmful impact on the imports resulting exclusively from a legitimate distinction at a regulatory point of view in order to continue with discrimination against a group of imported products. So we have many other cases. In the deforestation-free regulations and the CBAM, we see some differences, some treatment differences through some administrative burden in countries that are high-risk countries. And I'm speaking about the deforestation-free regulations, or those that try to be recognized because they have GHG mitigation standards that are equivalent to the CBAM. This might lead to challenges based on the MFN clause or the national treatment that discusses non-discrimination. Another possibility for this challenge is Article 2.2 on TBTs. Members shall ensure that technical regulations are not prepared, adopted, or applied with a view to or with the effect of creating unnecessary obstacles to international trade. For this purpose, technical regulations shall not be more trade restrictive than necessary to fulfill a legitimate objective, taking account of the risks non-fulfillment would create. So, there are some important CBAM factors and deforestation-free regulation factors that can be considered as technical regulations because they are high-stretch goals and they entail complex measurement. So these agreements might lead to some questions about the Article 2.2 of the TBT.
It is evident that if you take into account GATT 94, due to the decisions which allowed for restrictions to trade, this measure may be related to climate change, for example. And the key aspect here is the justification to protect, for example, human life, animal life, vegetation, according to Article 20b. But we know, because of our experience of jurisprudence in the WTO, that this is very difficult to prove. If you take CBAM, for example, there is an M missing here. What is the ultimate object? Is to reduce GHG emissions. And the European Union should use highly technical arguments for a panel to deal with the reduction, the global reduction of carbon. And it would yield an estimate. So they will have to face arguments which have the intention to protect Article 20b. Let me present the case of US free. The United States could adopt those measures because they were necessary and they were not necessarily restrictive to trade. They were not arbitrary. So this is a case that has to be seen with extreme care if there is an attempt to defend, for example, the Green Deal. Europe may use a case which may be of interest of those countries which feel they are affected and resort to the Green Deal and the rules of the WTO. Another significant aspect is the extraterritoriality question. Considering CBAM and anti-deforestation regulation, although they seem to be neutral because they are applied to domestic and imported products, what is the ultimate aim? It is global. So it wouldn't be extremely complicated from my point of view to accuse the European Union to attempt to impose a production policy which goes beyond its frontiers. Extraterritoriality is a concept which appears in the context of Article 20, but there is not a definition in contexts. We have to see Article 20G. Another test is the chapeau of Article 20. It cannot be unjustifiable, neither arbitrary. But let me show that extraterritoriality used to be quite flexible in international law as a whole. I mean, imposing one's own instruments. We're speaking about instruments which were originally private and they became official policies, governmental policies. And the text, and this is a question which is rather sensitive because it may affect the interests of a country which are affected by this compatibility between the rules and the WTO. Let me stress that there is a principle which was consolidated in the Framework Convention of Climate Change and which is among the principles of the Rio Declaration, which is the principle of common and differentiated responsibility. All of us are responsible, but these responsibilities vary depending upon the participation or the involvement of the countries. So considering all these regulations, although from the practical point of view, and perhaps the body, the relevant body of the WTO is not the strongest. We have to see that this is a principle which is interesting to developing countries, among which we have Brazil. There are some elements on which we may reflect the compatibility of these instruments issued by the European Union and others that may be drafted, as Pedro suggested. He mentioned the case of Great Britain and Canada, which may adopt these extraterritorial instruments. I mean, non-discrimination or other agreements like TBT. There is a set of possibilities. And let me speak about regional trade agreements. Brazil does not have this kind of agreements with developed countries. We have the chapter devoted to sustainable development, climate change and trade. And we also have labor standards with these notions, with the exception of the agreement between Mercosur and the European Union, which has chapters devoted to sustainability. In consonance with the Paris Agreement. So there is a clear connection between trade and the environment. There's a recent study from the London School of Economics which compare 8 different approaches to trade and environmental. We have the European Union, Australia, Canada, Chile, Japan, New Zealand, Switzerland, and the United States. All of them treat the question of environment and trade according to the framework and the Paris Agreement. From my point of view, it would be interesting for Brazil to advocate to apply the agreement of Mercosur and European Union, but also other agreements which are being drafted, for example, with Korea, Canada. So these regional trade agreements, according to the London School of Economics, contain chapters which deal with sustainability. Bioeconomy is okay, but in the Amazonia, but there is another thing that should be reflected upon when we speak about trade and the environment. The first thing to consider is green hydrogen. Green hydrogen is the future fuel, and Brazil has a great potential. But what is missing? We have to accelerate the adoption of regulation. The rule is being treated at the Senate with Bill 757 from 2022. So hydrogen has to be considered comprehensively, not only related to the sector of transportation. There is not a law in Brazil, but there are a dozen of projects involving billions of dollars, which are connected to the installation of production plants of hydrogen, of green hydrogen. So we have to consider green hydrogen as a significant commodity. This is a good which is highly interesting to certain markets, such as the German market. IRENA and the McKinsey & Company consulting project by 2050 an international demand of 600 million tons of hydrogen, and Brazil may have a domestic demand of 9 million tons and export 4 million tons to the United States and Europe. And as I have just a little time, there's something that has to be discussed at business level, and I'm referring to carbon credit markets. Before, a stock exchange dealing with carbon allows for the negotiation of those credits related to greenhouse gases and also to blockchain, which allows for sharing the goods and the data in a secure and immutable way. We may even foster in this way energy transition. And before has stated that big industries of countries such as the United States, Canada, Japan, France, and Saudi Arabia are interested in buying and marketing these credits. This is a bill which is at the Senate. So these things are treated at Senate level. There's a lot of focus on this kind of market. In sum, I wanted to share with you some of my reflection on these topics. Green Deal and its relationship with the WTO, because they are highly discriminatory instruments, and I want to call your attention on environmental policies that may be adopted in Brazil, which should be studied more deeply, as in the case of green hydrogen and carbon credit. Those are the things I can present after such a complete presentation made by Mr. Vega. Thank you very much.
Thank you, Humberto. Thank you, Pedro. You've been very generous time-wise. We are running out of time, but I want to tell you, I want to ask two questions from the audience. One is for Humberto. Can you briefly answer Marcio Gabardo? You recently participated in the expert group on the Forum on Trade, Environment and SDGs. seeking to identify the principles to be considered to design and implement climate and measures and trade policies. What's your opinion on these goals? Do we have the common but differentiated responsibility criteria, including the principles in the risk has raised controversy among the experts in the forum?
Muito obrigado pela pergunta, é muito interessante.
Thank you. It's an interesting question. I can only answer. I want to be very cautious here because this report needs to be submitted shortly, so it's not public. But I can tell you that there are some principles, actually.
Estamos propondo como princípios a serem levados em consideração pela OMC.
We are suggesting proposals to be considered by the WTO. One of them is common but differentiated responsibility. This is an important one. There's also a cooperation principle. When we speak about cooperation, we also refer to territoriality, measures that should not be taken unilaterally, that need to go through a coordination process. But even though I can't anticipate the report outcomes that will be submitted shortly by the end of September, before the WTO, that principle is included in our proposal. Thank you, Professor, for your answer. Thank you. Then Ambassador Ferrer Vieira's question. He thanks for the presentation, and regarding the new EU rule, CBAM and deforestation freeze beyond analyzing its consistency with WTO and GATT, in order to continue looking at the European market, what is the Brazilian government would be doing to support the private sector? Are you working on certification models, or is the Brazilian private sector only working on this? Who wants to take this answer? Humberto, Pedro? I can answer, but I don't know if I want to answer because I'm not informed as to what they are working on. I know that we have the private sector, the National Chamber of Industries participated in the public consultation, and the implementing regulation of CBAM reports that have been drafted. There's also a private consultation in Canada, and it's going through different stages in the UK, but I don't have additional information, just what I've just told you, no more than that. I can only add, but I imagine that the Brazilian government is thinking about this. I think the private sector is working on this and is concerned about potential barriers to exports. These studies were made, but I agree with Pedro in that the private sector is moving forward. But what the government wants to know is something that I really don't know. I also want to add something else. The government is announcing within this plan that Humberto described, and I mean the energy transition. The government wants to launch a trade system And this will take some time before it becomes operational because systems take a time to become operative. Brazil wants to become friendly with requirements in terms of carbon and what companies and businesses need to pay. And we need some answers to the EU measures. The EU system is completed through the CBAM. It's an externality. European emitters are going to be charged from 100 euros per ton of carbon emissions. And from the standpoint, the government standpoint, it should collect or charge the same price. Even if it were a 40 euro carbon price, it should be discounted from the value paid by European exports. This will not be an immediate outcome. What is immediate actually is the announcement. Brazil is creating an ETS based on the cap and trade system. Facilities emitting more than 25,000 tons of carbon per year. This is quite generic, but broad, in general, they are going to make a decision into this ETS system. This is a great initiative from the private sector. Absolutely, they are advocates, and the private sector were harsh. They hardly criticized this many years ago, but not now. So now they are taking a more positive outlook on this topic. And I mean the ETS, the emission trading system. So thank you very much for your comments. We thank everybody's time, our stellar presenters and the participants.